Joining us now to discuss it, former Deputy Assistant General Attorney General John Yoo. Great to have you here. And let's dive right in. Majority decision by the court. I don't know why this was so hard. Discrimination is discrimination, but what does this mean to the future of potential cases, and could this mean something to the Office of Civil Rights?
This decision means that no matter your race, no matter your sex, no matter your national origin, if your employer discriminates against you, you have a right as an individual, not as a member of a group, to bring a lawsuit under the Civil Rights Act of 1964. What struck me as bizarre about this case, which I did not know about until I read this decision, that there were some courts in the country, like the ones in Ohio, that were saying, but if you're from a majority group and you get discriminated against, it's going to be harder for you to bring your cases. And as the Supreme Court said, as Justice Jackson said, there's no support for that in the text of the Civil Rights Act. And if there were, I think it might even be unconstitutional. The Constitution and our laws treat each of us as individuals, and we cannot be treated as members of groups. That's the message from the court today.
White privilege doesn't have a legal definition, John, or the patriarchy doesn't have a legal definition. What this does, it just doesn't resolve this woman's claim. It just lets her, because this case had been dismissed, it lets her file suit again and pursue it, a legal path with it, correct?
That's exactly right, Dagan. Her case was just kicked out of court immediately because they said, since you're a white woman and you're claiming discrimination against you on behalf of a gay man and behalf of a lesbian woman, you can't even get into court because you got to satisfy a higher standard than applies to everybody else. And so the court, here the Supreme Court said, that's wrong. No, everyone's treated as an individual. And so she can now, Ms. Ames can now return to court, file her case, probably get things going, and then hopefully the Ohio state government will treat her better, maybe realize the error of its ways, and grant her some kind of relief.
It shouldn't be lost on us that this was a government agency acting in a discriminatory manner. That shouldn't be lost on us, should it?
No, I think there's two agencies who got things wrong. First are the courts in Ohio that were demanding, unlike other courts in the country, that a white person have to meet some higher standard to bring a court. But yes, you're exactly right, Dave. The real wrongdoer here, if the facts bear it out, because as Dagan said, we still are just at the very preliminary stages of this suit. If the facts bear this out, it was the state of Ohio, this Ohio government agency, that was treating her differently because she was a white woman in favor of, again, a gay man or in favor of a lesbian.
Another major decision today, John, from the justices, a unanimous one. The Supreme Court rejecting Mexico's $10 billion attempt to hold American gun manufacturers liable for cartel violence.
And a plot twist, liberal Justice Elena Kagan writing the opinion for the court, quote, Mexico here focuses on the manufacturer's production of military-style assault weapons, among which it includes AR-15 rifles, AK-47 rifles, and .50 caliber sniper rifles. But those products are widely legal and bought by many ordinary consumers. Now, first of all, I object, as someone who uses these weapons, to the military style. They're semi-automatic as sold, unless illegally modified. But to this decision to protect the manufacturer and to protect them from a foreign government, does this close down some of the internal cases being brought by these states, or does it not?
I think it will have some effect on them. Realize how incredible this case was. The government of Mexico, instead of handling the gun problem itself, or instead of going to the United States government diplomatically, they tried to go into our own courts, right? They went to our courts to sue our gun manufacturers. And there's a law, as you were mentioning, that says you can't just sue gun manufacturers as if they were the makers of a car in an accident. The federal law requires a higher standard that the gun manufacturers actually had to aid and abet some other kind of criminal activity. And the court here said quite clearly that wasn't met. Mexico could not show that gun manufacturers in the United States were somehow aiding and abetting the commission of crimes in Mexico. That's a Mexican problem. It's their crimes that they've got to solve. So I think you're right. There might be some spillover effects here for some of the domestic lawsuits because it's the same law that's at issue. And so those kind of lawsuits by states or even by individuals are going to have to meet this high standard. Can they show that gun manufacturers actually aided or abetted criminal activity? I think that's a very hard standard for them to meet.
Two important decisions, both unanimous, John. What a day. Thank you so much.
Thank you.
John Yoo.